Namaskar, hello and welcome viewers. You're watching this special presentation of Sansad TV, Bills and Acts, where we analyze bills that impact you, acts that empower you, and programs that matter to you. I'm your host, Kriti Mishra, and today the spotlight is on the appointment of judges in India. Before the detailed analysis, let's take a look at the highlights. Articles 124(2) and 217 of the Constitution deal with the appointment of judges to the Supreme Court and High Courts in India. The collegium system is the way by which judges of the Supreme Court and High Courts are appointed. Memorandum of Procedure is an agreement between the judiciary and the government. It contains a set of guidelines for making appointments to the Supreme Court and the High Court. So why are we discussing this today? Well, stating that the collegium system of appointing judges is opaque and not accountable, Union Law Minister Kiren Rijiju has said that he has to work with the present system until the government comes up with an alternative mechanism. The Law Minister said that after the Supreme Court struck down the National Judicial Appointments Commission Act in 2015, the government could have taken other steps, but it respected the top court's decision and did not act immediately to find alternate ways. He also said that the fittest of the persons should be elevated as judges and not those known to the collegium. So what's the way ahead? To ensure independence, reflect diversity, demonstrate professional competence and integrity? Let's find out from my esteemed guests. Joining us in the studio, Mr. Pinaki Mishra, Member of Parliament. He represents the BJD. Also joining us, Dr. Vageshwari Deshwal, Professor, Faculty of Law, University of Delhi. And joining us through virtual platform, Dr. Justice Satish Chandra, former judge, Allahabad High Court. In the studio, we also have with us young and vibrant audience. I welcome all of you on Sansad TV and thank you so much for joining us. And let's commence this discussion with the Member Parliament on our panel today. Mr. Mishra, coming to you. Now, judiciary, there is spotlight on judiciary right now in the country, whether it is about appointment of judges or the pendency of cases. Look at the pendency of cases, crossing the 4.5 crore mark. Look at appointment of judges. There is a raging debate. Your opening thoughts on the method of appointing judges in our country?
You know, I have to be a little careful because I wear two hats. I'm a senior advocate practicing in the Supreme Court of India. So I have to face the Honorable Supreme Court judges day in, day out.
Yeah.
So whatever I say here, therefore, has to be very measured and tempered, lest I fall foul of, how they feel about me. And I'm also a Member of Parliament who was in Parliament during the 16th Lok Sabha, when we passed the NJAC, the National Judicial Commission. And let's just remember that that was passed unanimously in the Lok Sabha.
Yeah.
And near unanimously in the Rajya Sabha. There was only one gentleman, my late friend Shri Ram Jethmalani, who on a matter of principle said that I'm not going to let the appointment system fall into the hands of politicians, let the judges appoint. So he was the sole dissenting note. Yeah. Otherwise, this was passed unanimously by both Lok Sabha and Rajya Sabha. I believe that this debate is not a new debate, whether the current system of collegium is opaque, not opaque. I think everybody recognizes the fact that it's not the perfect system.
Right.
We have to remember how the collegium system came in. It has nothing to do with Article 124 or with Article 217. Both do not speak about the collegium system. The Constitution doesn't speak about the collegium system. This is a system set up by judges for appointment for their own brethren. Every time in this country, the executive and the legislature has been somewhat weak. The judiciary has always, as the third pillar of governance, has always pushed back to assert itself. And that's what happened in the second and third judges' case during the time of Shri Narasimha Rao ji, as well as the time of Shri Deve Gowda and Shri I.K. Gujral, when the executive and the legislature were both very weak. They were hung parliaments, and therefore this system came about by the judges that they would appoint in terms of the collegium system. The NJAC tried to undo that. I believe the NJAC was good law. I believe the Supreme Court would have been very hesitant, and I'm aware of this for a fact, that the Supreme Court would have been very hesitant to strike it down the way it did. The government should ordinarily have had this pass through the inspection of the Supreme Court, but I believe that the government perhaps overplayed its hand. The Honorable Supreme Court repeatedly gave the government an opportunity to backtrack slightly I think the only objection that they had at some point was that there is likely to be a political interference with the law minister's part of the NJAC. So they said, let's try and work a system by which the law minister is not part of the NJAC, bring in any other constitutional authority. The government put its foot down, went hell for leather in court, and that's as a result. What should have been, according to me, a 4-1 verdict in favor of the NJAC became a 3-2 verdict against the NJAC. I don't know why, after 6 years, the government is still struggling to bring a new law. It's not as if the government in the past, in this particular government, has not tried to undo a Supreme Court judgment by bringing in fresh legislation. I think if we can tinker the legislation slightly, if we can ensure that the original objection of the Honorable Supreme Court is now met and we can go around it, I believe a new NJAC should be placed on the anvil. I believe again it will be passed unanimously, I have no doubt. And I think that would be the appropriate way going forward, because clearly everything is not right in the state of Denmark, as to quote Shakespeare. The collegium system has many, many loopholes.
I vividly remember that NGAC was passed unanimously, and of course there was a very erudite debate there. But Justice Chandra, coming to you, now we are talking about the NJAC. Parliament passed the Constitution 99th Amendment Bill and the National Judicial Appointments Commission Bill as well. However, both the acts were challenged in the Supreme Court and were declared unconstitutional and void. Now we agree on independence of judiciary, sir, that is paramount. But there is also a debate on the collegium system, the opaqueness, the nepotism part of it. How do you respond? Go ahead, sir. The floor is yours.
So first of all, I would like to tell this young audience that India is the largest democracy. In democracy, there are the 3 pillars. Briefly, one is the legislative, as my co-panelist, Justice Honorable MP has told, that first is the legislative, that is the parliament, who makes the law. Then executive is there to implement the law. And third is the judiciary, just to explain the law, interpret the law, and decide the cases accordingly. And in judiciary, we have 3-tier system for the young audience. That one is the lower judiciary, which is under the control of the state, and recruitment is through the local public service commission, state public service commissions. And now remaining the higher judiciary, which is the constitutionally guaranteed, that is the High Court judges and Supreme Court judges. As you know, that Article 124 and 217 defines the procedure for the appointment of the High Court judges. And it is as per the in the Article 124, it is mentioned that it is in consultation as deemed fit. Consultation with the Chief Justice as it deemed fit. But it was challenged. It was going on by the executive, but it was challenged in the SP Gupta's case, 30 December 1981, which is known as the first judges cases, where they demanded the correspondence between the government and the Supreme Court regarding the appointments. So that was the main point. And recommendation, it was held in this case, finally, just coming summarily, recommendation was made out that the executive will have the superiority in this appointment of the judges. But this after some time, in 93, 9 judges bench has decided on 6th October 1993, the second judge's case came, that was the advocate on record versus Union of India, and 9 judges were there, constitutional bench. Justice Verma wrote a detailed judgment, and there was some different opinion also. And they said that this is the matter of appointment of the judicial matter is the judicial family matter, and executive has no role. So they decided that it should be given to the CJI, and who will consult his colleagues. This was the result. And what happened after this one? Net result was this, that there was no public knowledge what is happening in the collegium, how and when decisions were taken place, when they met, nothing was there. And in fact, the president became the merely the approver, or just a rubber stamp just to put the seal on this one. And no role of the executive was there. So then there was a cry that collegium is not functioning very well for 5 years. Then the then president, K.R. Narayanan, has made a reference in 1998 to the presidential reference, and they asked about the present system, how it is working like this. In the meantime, 214 report of the Law Commission has come, and they suggested 2 ways. There must be the 3 senior most judges in the collegium, and the primarily the CJI or CJ of the High Court have the superiority, but appointment will have to be made by the executive. So this was the recommendation. And in 1998, in presidential form, they defined that there will be 3 judges, all these things, and present system is continuing. after the 1998
Yes, sir.
systems. This is the collegium system. I think now I have explained a little bit and briefly.
Yes,
Now
sir.
coming to the merit of this judgment or the collegium systems, there are pros and cons. Law minister, executive wants to get the power. Judiciary is not interested to leave the power. So this is the whole story going
Yes,
on. And these allegations also put up that strong cogent reasons were not given by the collegium when they supersede the judges of the High Court. This is the main allegation. Secondly, they said consultation, not in writing with the judges. And thirdly, the dynasty of the judges will continue. You have seen one judge in the Supreme Court who is recently appointed. You will see in his family 7 persons are judges of the high courts, various high courts.
Precisely.
Brother-in-law, son-in-law, all these things are there. And judges' sons are usually go to be elevated third generation, fourth
Precisely,
generation.
the charges of nepotism. Yes, sir.
Nepotism is there. And they also said that due to collegium, there is a politics among the judges. Politics, they are involved and they are leaving the judicial work and busy in the administrative work. For example, they said when a judge of the Supreme Court who is a member of the collegium goes to the High Court, the potential candidates and their wives are around him and they try to please. And so many CJs left their work and they are camping in Delhi for
Yes,
their
sir.
elevation.
You yourself are pointing out the flaws of the collegium system.
So all these points were there, and so that is why it is criticized.
Right, sir.
And National Judicial Commission, as rightly said, my former colleague, member of parliament, this was unanimously passed, and there was nothing wrong. If something wrong, the new bill will come and will remove
Absolutely,
that.
sir. So we'll wait for the new bill, as Mr. Mishra said. But Professor Deshwal, since we're discussing about the collegium system and appointment of judges, and we're talking about that collegium system and the flaws and the weaknesses in the system, but the government can also seek clarifications and raise objections. I'd like to understand the role of the government here.
Kriti, what the Constitution says is that appointments have to be made by the President in consultation with the Chief Justice of India. Now, after the second judge's case, this term consultation was interpreted to mean concurrence. What that implied is that now it was up to the Chief Justice totally, because what they said, it is not the Chief Justice alone, rather it's the entire institution of collegium behind him, because there were other senior most judges also who had supported the recommendation. So as it is now, the President did not have the option to say no. He was like supposed to do whatever the Chief Justice had said. But then after that, we had this National Judicial Appointments Commission, which was struck down. And then to strike a balance, a formula was evolved. To strike a balance between the powers of judiciary and the legislature. In a way, they said that we need to evolve a memorandum of procedure in appointment of judges. Now, as per that, what happens that whenever a High Court collegium recommends some names, it is sent to the center. The center then sends it to the state government for its opinion, and also the Intelligence Bureau for their inputs. All these opinions and inputs are then sent to the Chief Justice of India. Then he looks at them, and if he feels that it is appropriate, he recommends the name to the center. And then the Prime Minister advises the President. And then the President can either notify, either he can approve it and the names get notified, or then he can raise objections. And if he raises objections, the file is sent back to the Chief Justice of India, who then he might seek some further inputs, and then he might either reject on the basis of those inputs which he receives from the states and all, or he may reiterate the names. In case he reiterates the name, then as per this existing memorandum of procedure, now the center is bound to approve those names. But there is no fixed time frame during which they are supposed to notify the names. So as it is, now it is to be seen, it's basically a battle of nerves, who gives in earlier, because what has happened recently is that there were some names that were recommended. The state was sitting on those names, and those people, they like attained the age of more than 55 years, due to which now they are not qualified to be elevated anymore. So that is the reason why entire debate has again come into the public domain. But then we cannot overlook the right of privacy of those people whose names have been recommended. Okay.
Right, but
all
in
their
this turf
information-
war,
Huh.
the pendency of cases, that is burgeoning. I think that is the biggest concern. But before I take the questions from our audience here, Mr. Mishra, let me play devil's advocate here. Here we are talking about the flaws of the collegium system, but if we were to adopt the other system, then there'll be allegations of political shenanigans as well.
Look, let me tell you, until 1993, as the learned retired judge said, until 1993, the second judge's case, from 1951 to 93, the appointments in the hands of the executive, we've had some of the finest judges of our times who've come in those 50 years.
I'm sure.
Who have adorned both the high courts and the Supreme Courts. So it's not as if when the executive appoints, those appointments have been rotten, and now that the judiciary by the collegium system is appointing, that these appointments have been sterling. There are good apples, bad apples everywhere. Because at the end of the day, judges don't come from Mars. Judges come from within us, from the members of the bar, from the members of the lower judiciary. So therefore, this pick and choose, there is no difficulty. You will find one or two rotten apples, but you will find by and large people who want to come into public service, because this is a form of public service. The issue of the MOP that Professor just mentioned, I'd like to say that this MOP, the Memorandum of Procedure, is only a so-called MOP.
That's right.
Because this is now, I believe, adhered to more in the breach than by way of procedure.
Right. That's right.
The government simply, as she says, there is no time frame for it. The government just simply sits on it. And, high court judges particularly, sometimes they go past the age of 55, 56, 57 and feel they are no longer, they want to serve in the high court for 4 or 5 years and, then be not able to practice in that high court. So therefore, they just simply say, I withdraw my consent. That's the problem. So therefore, government, if they do not want to appoint somebody, the courts, the old saying, the courts don't have armies. So the courts can't send in armies to ensure compliance of their orders.
That's right.
At the end of the day, yes, the other day, Justice Call's bench, for instance, issued notice saying, why are you sitting on these appointments? It's really up to a well-meaning executive, a well-meaning government to understand that you cannot simply want pliable judges. If the collegium system has sent up names, unless there are some egregious examples of, why these judges should not be appointed, I believe there should be. One more very quick issue which I want to raise.
Yes, sir.
I believe this discrepancy of 3 years of retirement of the Supreme Court judges at 65 and High Court judges at 62 is what is responsible for what the learned judge just said about Supreme Court collegium judges going to the High Courts and High Court Chief Justices and other judges who are in the consideration kowtow to them. That only happens because of this extra 3 years.
Absolutely.
I have always said so since 1996. The way to go forward is put them at par, because it makes no sense to say a High Court judge should retire at 62 because he's too old, and suddenly on the last day of his appointment he gets appointed to Supreme Court and he becomes eligible to spend another 3 years and work for another 3 years. It makes no sense at all. And if you have this at par, make both, let's say 67 for instance, you will see all this will go out of the window. The good High Court judges, the Chief Justices, nobody wants to come to Supreme Court and retire in court number 7, 8, 9, 10, 11.
Absolutely, sir.
Unless there is a chance to come to Supreme Court and go into the collegium, as it were, or become Chief Justice, they're very happy being Chief Justices in their own High Courts. It's just this extra 3 years, which is the root cause of all problems. The root cause of the government having this power that, we will pick and choose and bring who we like. The root cause of why the collegium system has become, as Mr. Jaitley once, famously said, the rule of the unelectables, because they are people who are not answerable to anybody.
Right.
So therefore, I believe if you're really well-meaning, you should get both High Court and Supreme Court judges to retire at 67, ensure that there is parity of therefore retirement, and you will find this entire system, and plus the whole problem of of arrears as well.
Right.
It'll go a huge step forward, because these are good judges who are retiring now. This gentleman, the judge who we're talking about, at 62, he's in the prime of his career.
Absolutely, sir.
Why should he retire at 62 when he's fit to serve for another 5 years at least?
So, Mr. Mishra, I'll wait for your private member bills in the upcoming session on this particular issue. Let's take some questions from our audience here.
Private members' bills are again, thrown into the dustbin. You're aware of that. It has to be the government which has to bring this in by way of legislation. And I don't know why governments have not brought this in. Mr. Jaitley expressly agreed with me both personally and publicly. And he was law minister, he didn't do it. Mr. Sibal, whose junior I was, he didn't do it. Nobody I know who knows that this is the panacea to the problem does this. I don't know why.
Let's see how that pans out, but let's take some questions here. Please go ahead, introduce yourself and speak your mind. Please go ahead.
I want to ask if giving power to executive to appoint judges isn't like that the agent is being appointed by some higher authority, and
Sir,
he will work in the interest of that.
Firstly, let me tell you, nowhere in the world, Himanshu, do judges appoint judges. That's the first thing you have to remember. Everywhere in the world.
But there are also constitutional convention that judiciary is the protector of the constitution.
let's
No
give the floor
doubt,
to Mr. Mishra.
no
Yeah.
question about that. But I'm not asking for untrammeled power like there was from 51 to 93. I'm not
Right.
asking for untrammeled power. Even the NJAC has a number of built-in safeguards. What it does is that the actual spirit of consultation, which is there in Article 124 and 217, that spirit of consultation is brought about by a wider body where simply judges don't exist, like in the collegium system. There are people from outside. I mean, if you say you can't trust the Prime Minister to be part of the selection process, that's a bit rich.
Exactly.
I
Where
mean,
else do you go then?
The Speaker of the House, the Prime Minister of the country. I mean, these are very high public functionaries.
Absolutely.
So you have to trust them. They are also supposed to be part of the NJC.
Let's take another question now.
My question is, does nepotism exist in India? And if so, why do we see very low number of judges from lower caste in High Court and Supreme Court and very high number of judges of higher caste?
Justice Chandra, that question is addressed to you. What about representation?
Yeah, that is there. First of all, there is no reservation in the judiciary. So there is no question of the caste base. The appointments are always made on the merits. Exception may be there sometimes, as my colleagues, Mishra, Member of Parliament, said, one or two wrote an appeals came somewhere, but there is no reservation, so always on merit. This is the first aspect. And regarding the nepotism, I already told you, and I will take the lead just to conclude this one. The
Yes.
age of 65 and 3 years is the main cause for this collegium.
Yes.
And as Mishra rightly said, Honorable Mishra rightly said, this is there. And in India only in India, judges appoint the judges.
Ma'am, my question is that CJI sir recently said about that he has the list of advocate to appoint like as a judge in various courts. So it maybe support the nepotism or like that they have
Again,
the
those
that power.
allegations, sir.
Look, I'm the first one who's going to say that yes, there is an element of nepotism which is there in the judiciary. The difficulty is in India, in the particular structure that we have, nepotism is rampant everywhere. If you see a doctor's son will be a doctor's grandson will be a doctor. They'll all be handling the same, clinic. Engineer, an architect. So nepotism in that sense is rampant everywhere in India. It's not just in the legal system. Members of parliament, their children become members of parliament, their grandsons they become
Yes.
members of parliament. So this is not as if nepotism is a hallmark only of the judiciary. This is, you're right, a part of a larger organic problem that we have going over thousands of years, where unfortunately caste system, which has been enshrined in our system, ensures that merit really that should be seen from the lowest end of the spectrum doesn't very often get seen. I completely agree there. I'm mindful of that. It'll take us time before we evolve as a true democracy where only the rule of merit survives.
Let's take the last question quickly.
Judges are public servant, not the. And when we talk about the public servant, MLA and MPs are also public servant, but they are elected members. They are not by the collegium. If I don't point out the name, if anybody is the CGI right now and he appointed the High Court judges as his son, and later on he became the CGI of India, then we say that the nepotism is here.
The current Chief Justice of India, Justice Chandra, his father was Chief Justice for 30 years back. I have appeared before him when I just joined the bar. Now, I believe there is possibly today no one with the kind of sparkling intellect that young Justice Chandrachud has, the son has.
Yes.
I believe he's one of the finest minds. Would you call
Absolutely.
would you call him a product of nepotism? No, I would not. Because if anybody deserves in this country to have been a High Court judge, to have been a Supreme Court judge, and now to have become Chief Justice of India, it's him. So therefore, whole nepotism is a word easily bandied about. Again, like I said, there will be 1 or 2 or 5 or 10 egregious cases where nepotism has worked wrongfully to give someone a leg up. But by and large, if a judge's son is very bright and is completely capable of handling his responsibilities, to the best of his ability and to the best of his position, then I believe that's not nepotism.
Right.
That when you say that a MP's son can be elected and therefore that gives him the imprimatur, similarly here competence and merit will give you the imprimatur.
Let's not deny that
So
opportunity.
let's not deny him that
Yes.
opportunity simply because he's somebody's son.
Absolutely. That's a very valid argument. Last question.
पूरी लिस्ट जो है वो जजेस की अपॉइंटमेंट की जो पार्लियामेंट और प्राइम मिनिस्टर के थ्रू होकर ही गुजरती है, तो फिर एनजेएसी और इस तरह की कमीशन की क्या ज़रूरत है कि जिसमें कि लॉ मिनिस्टर एंड
के थ्रू होकर नहीं गुजरती है. मैम, I'll give you the floor.
See, I'll tell you that in our country, as Justice Chandra had earlier elaborated upon, there is a separation of powers, and independence of judiciary is extremely vital for that. Why this entire debate is going on is about nobody is averse to the fact that there should be primacy given to the judiciary in appointment of judges. The issue is with the exclusivity. And as they say that the only consideration is merit. Okay. But then when we talk about merit, there should be certain parameters or guidelines how we will judge a person on that merit, whether the person is actually meritorious or not. Coming to this nepotism debate, obviously a doctor wants his kids to be doctors, a defense personnel wants his children to join the defense services. But there is a set written examination, an interview, a board that needs to be cleared. Okay, and then see what the Constitution says. Let's see who can be in the list of people who can be appointed as High Court judges or Supreme Court judges. It says that there can be an eminent jurist.
Right.
Till
Right,
date, not a single eminent jurist has been appointed.
Completely out of time. I'll give the closing remarks to Justice Chandra there. Sir, please go ahead.
There are the few judges who have not qualified the municipal magistrates examination, but they became the High Court judges directly because there is no measurement. And at the time of their elevation, the Chief Justice of the High Court invites the judgments where they appeared, but nobody reads it. Hardly anybody reads. This is only the recommendation. They came out and they were selected to the constitutional positions. That is the only thing. So my perhaps youngsters wants to say that there must be, as Madam said rightly, there must be some examination or some face or interview or something like that. Even for the PN, there is an interview. But for the High Court judges, there is no interview at all.
I'm absolutely out of time. Thank you so much for joining us, Mr. Mishra, Professor Deshwal, and Justice Chandra. Well, viewers, that's all I could pack for you in this edition. Thanks for watching and stay tuned to Sansad TV. Goodbye from my side for now.